Many people believe that strength in court comes from numbers, more judgments, more printouts, and more citations. So, they prepare files that look heavy, arguments that sound busy, and research work that looks exhaustive. But in reality, this habit weakens cases far more often than it strengthens them. In this lesson, we will talk about why one good judgment is better than 50 weak citations and how over-citation damages credibility in court. People oversight for understandable reasons. They believe more cases show hard work, more citations means stronger preparation, and fewer cases may look risky. Over-citations is like insurance for them. The belief behind this is very simple. They believe that if one case fails, another might work, and if one paragraph is questioned, another can be shown. But litigation does not reward defensive preparation, it rewards confident precision. In courts, over-citation often appears differently than people expect. When the court is presented with long lists of case names, multiple compilations, and repeated principles stated in different words, the focus shifts away from the issue. The court begins to ask, which citations really matters here? Why are so many case laws being relied upon? And is there a clear principle being advanced at all or not? Instead of strengthening submissions, over-citation often creates confusion. Now, the courts needs to spend time filtering material rather than engaging with the core submission. And when this happens, the argument loses direction, not because the law or the case law is weak, but because it is presented without restraint. Every citation you place before the court is a credibility bet. When you cite a loosely connected judgment, a factually different case, and a decision that does not answer the issue in your case, you lose a little credibility. And the credibility does not drop suddenly, it erodes quietly. So, by the time you reach your strongest case, the court might already be skeptical. And this is the reason why weak citations are dangerous. A strong judgment has three qualities. It answers the exact issue before the court. It fits the factual context and it comes from the right authority. And when you use one such judgment, the court understands your direction. The arguments feels controlled and the principle lands clearly. The court does not feel burdened. Instead, it feels assisted. Strategic restraint is the ability to stop researching when the answer you are finding is found. Resist the urge to add one more case and trust the strength of your best citation. Most people struggle with restraint because they confuse effort with effectiveness, they fear being questioned, and they don't trust their own analysis. And this lesson is about building that trust. When a senior reviews your research, they don't ask, how many cases have you found? They ask, on which case are we relying on? And if the answer of this question is unclear, your research is weak, no matter how thick your file is. Seniors always value clarity of thought, confidence in selection, and the ability to defend why a citation was chosen. You should always remember, over-citation signals uncertainty. Here is a practical rule people can adopt. First, they should find the best judgment. Then, they should test it with the facts and build arguments around it. They should add another case only if it adds something new. If another case does not clarify, strengthen, or resolve a gap in your arguments, then do not include it. Remember, the court always remembers your strongest case, and not the entire list. Once you stop over-citation, it helps you in four ways. Your research becomes faster, your arguments become sharper, your submissions are cleaner, and your confidence improves. More importantly, once you stop over-citation, the court starts to trust your judgment. And once a court trusts your judgment, even brief arguments given by you carry weight. Understanding strategic restraint naturally leads us to the next question, which is, not all judgments carry the same authority. So, in the next lesson, we will discuss the hierarchy of legal sources and why knowing what carries weight is more important than knowing what exists. Thank you.